So I'm delighted to introduce our next panel, which is who are going to be speaking on analyzing the constitutional doctrines on which the justices relied. We'll just go down the row, I think, in terms of speakers. So our first speaker is Professor Andrew Koppelman. He is the John Paul Stevens Professor of Law and Professor of Political Science at Northwestern University. And his scholarship focuses on issues at the intersection of law and political philosophy. He is the author of numerous, over 80 articles and books on a wide variety of constitutional issues. His most recent books are The Tough Luck Constitution and The Assault on Healthcare Reform. And the other one is Defending American Religious Neutrality. Both of those are out in 2013, astonishingly. And he is also an occasional contributor to the Balkanization blog. Our second speaker is Sharif Girgis, who is a philosophy PhD student at Princeton and a law student at Yale Law School, where he is also an editor of the Yale Law Journal. He has written on social issues in academic and popular venues, including the Wall Street Journal, the New York Times, the National Review, the Yale Law Journal, the Harvard Journal of Law and Public Policy, and he is also the co-author with Robert George and Ryan Anderson of a 2012 book entitled What is Marriage? Man and Woman, a Defense? Finally, our third speaker will be Nancy Marcus, who is assistant professor at Indiana Tech Law School, where she teaches constitutional law. She holds a JD from this institution, from Case Western, and also an LLM and an SJD from the University of Wisconsin Law School. She has a really diverse range of academic and advocacy experiences, including working with various organizations such as the Alliance for Justice, the American Association for Justice, and the National Abortion Foundation. She has also worked as a legal aid lawyer in rural Ohio and as a law firm lawyer in Cleveland. Throughout her career, she has spoken at a number of conferences on a broad array of legal and constitutional issues. And two of her articles have been cited by federal courts in their recognition of emerging doctrines and trends on Beyond Romer and Lawrence, which was in the Columbia Journal of Gender and Law, and the Freedom of Intimate Association in the 21st Century in the George Mason Civil Rights Law Journal. So I will turn it over to them. No further ado.
It is a truth universally acknowledged that the big question the Supreme Court evaded in United States versus Windsor is this: what is the appropriate level of scrutiny for classifications based on sexual orientation? The only problem with this truth universally acknowledged is that it isn't true. This question was not presented to the court in Windsor because the Defense of Marriage Act does not classify on the basis of sexual orientation, and lower courts were wrong to claim that it did. DOMA declares in pertinent part that the word marriage, whenever it appears in the US Code, I'm quoting here, means only a legal union between one man and one woman as husband and wife. It makes no reference to sexual orientation, but it does speak of man and woman. It classifies on the basis of sex. Sex-based classifications are presumptively unconstitutional and subjected to intermediate scrutiny. The court avoided this rationale for its result, I think probably because it did not want to reach the question of whether states could deny same-sex couples the right to marry. But the reasoning the court did rely on, I'm going to claim, was correct and sufficient to dispose of the case before it. The equal protection argument that the court relied on has nothing to do with levels of scrutiny. It looked past that heuristic device to the underlying purposes of equal protection. And this is a rare but appropriate response to an unusual kind of law, one that singles out a particular class and imposes an unprecedentedly broad disability upon it. So let's start by explaining why I think this is not a sexual orientation classification. So what do we mean when we say that a law classifies on the basis of a trait? How do we know when that's happening? Here's how we know. A classification is based on trait T if it requires state officials in allocating rights and burdens to determine in specific cases whether that trait T is present. So legal consequences must turn on the presence or absence of the trait. That's what it means to classify. So we're classifying on the basis of age when we say you have to be a certain age in order to be allowed to drive a car, because the person who's deciding whether to issue the driver's license needs to figure out what age you are. That's what it means to classify. In Brown versus Board of Education, the state had to determine the race of each individual student in order to decide what schools to place them in. With sex discrimination, Frontiero versus Richardson invalidated a law that automatically allowed male members of the Air Force to claim their wives as dependents, and thereby receive housing and medical benefits, but female members had to prove that their members depended on them for more than half of their support. If Sharon Frontiero had been male, she would have gotten the benefits. That's how we know that it's a sex-based classification. So here's the problem. Neither a state law denying same-sex couples the right to marry nor the Defense of Marriage Act require any official to determine anyone's sexual orientation. Some laws do. The military used to try to figure out whether people were gay in order to decide whether to expel them or not. That's a sexual orientation-based classification. But these laws, and I should also say it is possible for a facially neutral law to reflect a purpose to discriminate. If the law is facially neutral but reflects a purpose to discriminate against same-sex couples, then it might discriminate. I think that I'm going to agree with Maggie that the aim of the marriage laws was not, and has not traditionally been, is not even now. Certainly a lot of the states that have laws restricting marriage to opposite-sex couples, it's not about a desire to inflict damage on same-sex couples. This is focused on the value of a certain kind of heterosexual union, and the existence of gay people is a side issue. So on this account, I think Maggie described it very well, so I'm not going to dwell on it here. The function of marriage law is to protect a human good that gay people happen to be unable to realize. So marriage laws don't discriminate against them any more than art museums discriminate against blind people. So I don't think that you've got a sexual orientation-based classification here. On the other hand, it doesn't matter, because the law is already well settled that classifications on the basis of sex are presumptively unconstitutional. They require an exceedingly persuasive justification. Windsor presented exactly the same case as Frontiero versus Richardson. If Edith Windsor had been a man instead of a woman, the tax exclusion would automatically have been granted. She was denied the exclusion only because she was a woman. A state official had to determine what sex she was in order to decide how the law was going to treat her. That is a sex-based classification. Now, I'm arguing against the great weight of legal authority here. Most judges who've been presented with this argument have rejected it. The argument goes, well, there's no sex-based classification because persons of both sexes are equally forbidden to marry a person of the same sex. Now, this is inconsistent with Supreme Court precedent, which rejected a structurally identical argument in favor of miscegenation prohibitions. But set that aside, let's imagine a different, equally symmetrical statute. No person, this is true of persons of both sexes, no person may perform a job traditionally performed by the other sex. If you accept this argument, that's not a sex-based classification because it applies to both sexes equally. Or a statute that requires courts to give custody of male children to fathers and female children to mothers. By this reasoning, that's not a sex-based classification either. Now, some of the courts that have rejected this argument have also imported into the equal protection analysis elements that the court just hasn't required. Say, a rule that's separate but equal doesn't violate equal protection, or a rule that sex classifications are permissible unless the challenger shows that they were adopted with the purpose of subordinating women. I don't know how you show that with any statute. I certainly don't know how Sharon Frontiero could have shown that. So the court could have disposed of the case on sex discrimination grounds. Well, why didn't it? They were clearly aware of those grounds. It actually came up in the oral argument in Perry, and both Kennedy and Ginsburg indicated that they thought it had some merit. This would have been doctrinally tidy. You just would have had to build on existing doctrine, and it wouldn't have required the court to craft any new law. On the other hand, it also would have reached the court the question that the court worked quite hard in Perry to avoid by effectively declaring the presumptive invalidity of every law in the country denying same-sex couples the right to marry. And the court was not eager to reach that issue. In fact, looking at the pamphlet that you all have, the amicus brief in the Perry case that I'm one of the signatories to has a footnote warning the court, you're going to go down this road, you'll end up with the sex discrimination argument, and then you're going to have to decide whether Koppelman's right, and you don't want to do that. All right, so what the court did was it relied on a line of cases that hold that a law is invalid if it reflects a bare desire to harm a politically unpopular group. Now, this is a problematic line of cases to cite because, and Maggie is right again, she keeps on being right, that it is not the case that all opposition to same-sex marriage reflects a bare desire to harm gay people. She's just right about that. So what sense can we make out of the holding here? Well, the most important predecessor to Windsor is another Kennedy opinion, Romer versus Evans, which struck down an amendment to the Colorado Constitution declaring that neither the state nor any of its subdivisions could prohibit discrimination on the basis of homosexual, lesbian, or bisexual orientation. And Justice Kennedy said that this amendment has the peculiar property of imposing a broad and undifferentiated disability on a single named group. It didn't even abolish all the statutes in Colorado that prohibited discrimination on the basis of sexual orientation. Discriminating against heterosexuals because they're heterosexuals was still illegal. It was only this group that had protection withheld from them. And Kennedy said that that violated equal protection. So the broad holding of Romer, I think, is if a law targets a narrowly defined group, just on its face targets a narrowly defined group, and then imposes on that group disabilities that are so broad and differentiated as to bear no discernible relationship to any legitimate governmental interest, then the court's going to infer that the law's purpose, not the subjective purpose of the framers, but the purpose that it's hard to do that with in the case of Colorado, a law that was enacted by referendum. You'd have to get into the minds of all of the tens of thousands of voters and figure out what their intentions are. You can't do that. But the purpose on the face of the law is just to harm that group, and a bare desire to harm a politically unpopular group can't be a legitimate state interest. Well, there are similarities between DOMA and the amendment invalidated in Romer. It identifies persons by a single trait and denies them protection across the board. For the first time in American history, it creates a class of second-class marriages valid under state law, but void for all federal purposes. So why would you do that? It at least arouses suspicion. Well, the only justification for the law that Justice Scalia offered was that this avoids difficult choice of law issues that will now arise absent a uniform federal definition of marriage. What's going to happen if a couple gets married in New York and moves to Alabama? So Justice Kennedy says DOMA avoids all of this uncertainty by specifying which marriages will be recognized for federal purposes. But this happens all the time. Federal laws raise choice of law issues. And federal agencies have addressed those problems for well over a century. There's also a problem of the proportionality of the response. Conflict of laws problems don't arise that often. This is why for a long time, almost nobody noticed that federal law is unclear about the choice of law problem. And in a country with thousands of same-sex marriages, it's remarkable how few of these cases are written. I wrote a book in 2006 about what happens when same-sex marriages cross state lines, and ever since then, I have been looking for cases So I can say, hey, I'm an expert. I can talk about these cases. There's no cases. Doesn't come up. I got to find another line of work. So here I am. Now, once every few years, DOMA might simplify some federal bureaucrat's job, but everybody else has enormous burdens. So thousands of employers in states that recognize same-sex marriages have to recognize two separate administrative regimes for benefits, one that handles federal benefits and one that handles state benefits. There is a whole small industry of compliance specialists who help businesses to try to cope with these regimes. It doesn't even ease administrative burdens for government actors. It creates enormously complex problems for bankruptcy courts because marriages create property rights, and you can't just decline to recognize those property rights because they arise under a same-sex marriage. That would violate the takings clause. Tell somebody that you've got these marriages, these rights fully vested under state law, and we're just going to take them away from you because it's a same-sex marriage. You can't do that. So huge headaches. And the federal interests that are jeopardized here. I'll only cite one. The military can't provide its members' families with health care, housing, and survivor benefits, which are absolutely essential to military effectiveness. So what the court has done in these bare desire to harm cases, it says, if in a case where we single out a particular group for enormous broad disabilities, very few statutes like that. When that happens, then that suggests that the purpose is a bare desire to harm an unpopular group. And we're going to ask the state, all right, so why did you need to do that? And if the state can't provide such a rationale, then we're going to presume that there is no such legitimate interest and invalidate the law. Now, this is only in a very narrow set of cases, and there's plenty of room for disagreement about whether a case is or is not at the boundary. Certainly, I think laws just refusing to recognize same-sex marriage are not within this sphere. This approach lacks the mechanical clarity of the levels of scrutiny approach, which just asks what kind of classification is being made. That's why Romer has had very little effect in the lower federal courts, some of which just note, well, you didn't speak of strict scrutiny, therefore minimal scrutiny, therefore we uphold the statute. And Windsor leaves an even thicker fog because it combines the Romer analysis with an invocation of federalism, and the weight that federalism has in the analysis is something that exceeds my expertise. I hope someone will explain it to me. So Scalia correctly observes that the lower courts are probably going to find Windsor easy to distinguish from any case that comes before them in the future. I think Scalia is right about that. So I think that Windsor is unlikely to have much effect in the lower federal courts. Maybe it tells you something about what will happen if same-sex marriage comes before the court again with this particular collection of judges, but some of them are getting old, so I'm not sure that that's what's going to happen. A lot, I think, depends on the results of the next presidential election. But as a matter of pure equal protection theory, these laws were unconstitutional. The court was right to get rid of them. Larger questions were postponed for another day, but the basic equal protection holding of Windsor is sound.
Thank you, and thanks so much for inviting me, for having me here. It's such a great honor. Obviously, it's especially an honor to be back on a panel with Andy Koppelman. I know it's like typical of academic chumminess to say, oh, Andy's an old friend. But in this case, I really do like him, and I really do respect his work. I think he's a model of having a really good discussion, showing intellectual and moral seriousness in a really difficult topic. And we've discussed the merits of the issue before. And in fact, in one case, it was a debate at Harvard Law School. It was covered by C-SPAN. So if you want to see our view on the merits as opposed to the legal issues, you can join the other 12 people who've seen that video on the C-SPAN website. And I say that—
Be there forever.
I hope so. And I say that partly because I really am going to bracket the first order issue of whether it's a good idea to recognize same-sex relationships as marriages, because I think I have a thesis about the constitutional reasoning that at least a lot of people who think that's the right thing to do, and in fact who think it's in keeping with truth and justice in the American way, then you can believe that and agree with me, at least some of you, on the constitutional issue. But first I should start with a bit of a story. I guess like a lot of people in this room, I was eager for the day with the decisions to come down, and I woke up Thursday morning, I went to work, and then I promptly put my work aside for about an hour and a half, and I was refreshing on SCOTUS blog at 9:53 onward. And then it came up, and I clicked on the PDF for the DOMA case, and I just sort of scrolled through, and then I started reading something, and it was remarkable. My co-authors and I, Robbie and Ryan, had been going around the country day in and day out, law schools, universities, all kinds of groups, making a couple core claims, and in particular, making about 5 discrete points about the legal issue, the legal framing. And there I was, in the opinion, reading those 5 points, in that order, with our idiosyncratic terminology, and even with a couple citations to us. And then, of course, it registered that I was reading a dissent. So, I'm obviously talking about Justice Alitos' dissent, and now instead of making those 5 points in my own voice, I'm going to make them in his voice to bootstrap their authority, dissent though it is, because I think he makes a very important argument, and then I'm just going to supplement it with a brief response to his conclusion, to an argument that Andy has made against that conclusion. The conclusion is this, the thing that I think I can get some of you to agree with is this. To get to Windsor, you can't just apply constitutional values, including equal protection. You have to get the court to assume a substantive position on moral and political issues on which 2 things are true. 1, the Constitution itself is silent, and 2, there are reasonable alternatives. So this isn't just going to interest originalists. You can think that it's perfectly legitimate for the court to have a more developed or expansive view of how to apply constitutional values, but still think they have to be constitutional values, unless there's a statutory basis or something like that. So it still might interest you if you're not an originalist, but it's that claim. And obviously the response is, no, all they did was apply equal protection. And that's the kind of argument that I'm going to address through Justice Alito. First preliminary point is I'm with Professor Koppelman that I don't see how federalism works either as a standalone basis for the decision or in some kind of metaphysical fusion with equal protection. And I'm happy to talk about that during Q&A, but I don't see how the argument goes through. And the second preliminary point is that whatever justifies the federal government's involvement in marriage in the first place, I think once it is involved in the narrow way that it is, both sides of this debate will be interested not just in what either the concrete benefits that same-sex couples get if you're pro, or in public fisc and uniformity and choice of law issues if you're in favor of DOMA. I think both sides will also be interested in the message, the cultural message that's sent by the federal government's own understanding of marriage. That's part of what's at stake. This is just as much a cultural battle once the federal government gets involved, whatever justifies its involvement. If you're pro, you want the federal government to teach that marriage is just the kind of intimate bond that 2 men as well as a man and a woman can have. And if you're in favor of the traditional view of marriage, or the conjugal view of marriage as we call it in our book, then you want the federal government, if it's going to be involved at all, to teach that truth as you see it about what marriage is and why the state's involved. So those are the preliminary points. The first substantive point on which I want to invoke His Honor is the idea that the equal protection framework, most of our jurisprudence on equal protection is awkward to apply to this case. It's ill-suited to this issue. To use Justice Alito's words, it is ill-suited to this case. Okay. What are the reasons? Professor Koppelman has covered some of them. So one thing I agree, it's conceptually neater, and in that sense, it's a more useful heuristic to limit classification to the kinds of cases that Professor Koppelman is talking about, and on that basis to say it's not a sexual orientation classification. Of course, it's disparate impact, but disparate impact is only going to be relevant under the Equal Protection Clause if that's evidence of something else, which is a discriminatory purpose. And I think, again, Professor Koppelman is absolutely right. There's no basis for saying it's just that. And in his paper, he mentions some of the reasons. In our book, we mentioned some. To just give you a quick sketch, I mean, the idea that marriage is a relationship of a man and a woman arose centuries before our modern concept of a gay identity. It arose in cultures that were extremely favorable towards same-sex sexual relationships in general. It arose in cultures that had no connection to Judaism or Christianity or any other religion that you might think is the main source of moral objections to same-sex conduct. So it's just, historically, it falls flat to say that the only basis of this vision of marriage could be animus towards a group that most people had nowhere on the radar as a class at the time that these laws were being implemented all over. But I want to go a little bit further than Professor Koppelman, and I want to say there's even an important difference between this case and other and sex discrimination cases. In Frontiero, Sharon Frontiero doesn't get her benefits because she's a woman, end of story. There's no scenario in which she's a woman, the policy stays the same, and she gets the benefits on the same terms. In Weinberger v. Wiseman, there's no case in which Stephen Wiseman, gets his benefits under the Social Security Act for being a widowed father because he's a man, because he's a father and not a mother. Again, there's no scenario in which that's different. Even in the other cases that Professor Koppelman mentioned, the more hypothetical ones, same thing is true. You zero in on the gender. I don't think this DOMA discriminates on the basis of orientation because it doesn't ask that question. I don't even think it really discriminates on the basis of sex because it's not discriminating on the basis of an individual property at all. It's discriminating on the basis of a feature of a couple as such. Unlike Sharon Frontiero, unlike Steve Wiseman, Edie Windsor gets the benefits if she's in an opposite sex relationship. She doesn't if she doesn't. Now, of course, that's not the end of the equal protection analysis. It's just, I think it does point to a bigger question, though. Equal protection analysis now shifts to the question of whether it's irrational or arbitrary to require a marriage to be opposite sex. It's now asking about the fit between marriage and a feature of a couple as such. It's not focused on the value or the dignity of an individual, thumbs up or thumbs down. So it's an important framing question, even if it doesn't end the debate. And that is the second point of agreement with Justice Alito, is that this debate doesn't turn on whether you value gays and lesbians equally or not. Everybody in the debate could be valuing gays and lesbians equally, and then it turns on the question of what makes a marriage. What's distinctive about this kind of relationship? Why is it one the state's involved in the first place? To quote His Honor, this point fundamentally turns on what marriage is. Okay. And that the invitation to recognize same-sex relationships as a marriage is an invitation to adopt one substantive view of the answer to that question over another. Justice Alito, they're really seeking to have the court resolve a debate between two competing views of marriage. That's the main claim. Now, the third point of agreement is on the broad characterization of the main view on offer in the proposal to recognize same-sex couples as marriages under federal or state law. That vision of marriage is mainly of marriage as a certain kind of intense emotional intimacy between two adults. And the reason the state's involved is because there's social value in affirming that intimacy, that bond. You can think about this hypothetically. You can think of two men who are in a relationship, who share a home, committed to sharing all the burdens and benefits of common life for the long haul. If they are brothers and they have a platonic bond, they don't get recognition even under the new scheme. If all the circumstances are the same and they share an intense emotional union of the quality that we typically associate with romantic and sexual bonds, they do. So the defining feature of marriage, what makes it distinctive on this view, is a certain kind of intense emotional intimacy. All I have to get you to believe about for this argument to go through is A, that something in that vicinity is right. And in fact, actually that's it. Now, Justice Alito in the footnotes goes further and says, now some people oppose the adoption of this vision not because they think gay people matter less, not because they think gay people can't have a stable bond, but because they think that teaching generally that that's what makes a marriage would make choice the ultimate criterion. And that, as a social rule, would undermine the kind of general enforcement of stabilizing norms where a particular couple might not feel that they serve those norms serve the emotional intimacy that they have, right? So if sexual openness serves emotional connection in a particular bond, it will become just as arbitrary and discriminatory if what really makes a marriage is emotional union, to encourage that in any kind of way publicly. So that's the third point, the characterization of the view on offer. The fourth point is the characterization of the alternative view. Now, in the book, we call it the traditional or the conjugal view of marriage. We give a philosophical analysis of it, but all I need you to believe is not that it's right, but just two things. One is that in that view, complementarity is intrinsic to what makes a marriage. It's not an arbitrary requirement. It's not an ad hoc kind of addition. It's not an appendage. It's really integral to what makes a marriage. And the quick formal sketch of why is that we think what's most fundamental to marriage, and we think we can show this from intuitions on both sides of the debate, is comprehensiveness of union, and that several things flow out of that. One of them is complementarity, but one of them is exclusivity, one of them is permanence. We even think that a certain kind of connection to family life flows out of that. But the core thing to believe is that A, is a view on which, at least internally consistent, on which complementary flows out of it and is not just an arbitrary add-on. And B, you have to believe that the view itself is not ad hoc. And here again, I mean, that it wasn't just cooked up in 2011, just in time for publication during the court's term, right? And I think there the evidence is simply that it's continuous with long traditions of reasoning about what makes a marriage and why it's of social value that arose long before same-sex relationships were on the table. They were discussing, for example, what makes a marriage completed, when the whole question was what kinds of acts between a man and a woman can count, right? So that it couldn't have been motivated there by a kind of animus against a class that simply wasn't a part of the discussion. And B, whether you want it to be religious or philosophical, I think there are deep parallels. You know, and we try to bring out some of these, but John Finnis and other work brings them out to a greater extent. Not just with the Genesis concept of one flesh union, but with understandings of what makes marriage different, what makes for a total union in Plato and Socrates and Aristotle and Xenophanes and Musonius Rufus and Plutarch, especially Plutarch, actually, as it happens. Deep continuity. So that's all I need you to believe. It's not ad hoc that it's intrinsically opposite sex, and it's not ad hoc, the whole view itself, which says that it's intrinsic, it's not ad hoc. And indeed, here Justice Alito says, where is it? He says, this older view, which I will call the conjugal view, sees marriage as intrinsically opposite sex. Okay. The evidence, by the way, that the alternative view is emotional union is not just in Alito, it's not just in my crazy hypothetical about the brothers, it's in Kennedy's opinion, and it's all over Kennedy's opinion. Kennedy says at one point, he says straight out, that the state's interest in marriage, that part's paraphrased, but that's what he's saying, is based on the idea that consensual sexual intimacy between two adult persons of the same sex can form but one element in a personal bond that's more enduring, and there he cites himself. And then he says at another point, his characterization of marriage is a far-reaching legal acknowledgement of the intimate relationship between two people. I would invite you as an exercise to go through his opinion and make the equal protection argument work without that substantive assumption about what marriage is and why there's legal acknowledgement of it. And I think it's impossible to do. Okay, so the fifth point is very simple. You've got this core question about what the debate's really about. It's really about what marriage is and why it's relevant to policy. It's not about simply whether to expand or restrict the pool of people eligible to marry, as if we all shared already a conception of marriage. For that reason, the kind of individual rights analysis that our equal protection jurisprudence is most comfortable with is just an awkward fit. You really have to ask whether it's arbitrary to think that marriage is opposite sex. To answer that, you have to have one of two substantive views of marriage, something like the conjugal view or something like the emotional intimacy view. And the fifth point, very simple, is that on that question, the Constitution is silent. Constitution is silent. If you want, however much you want to stretch the 14th Amendment or the 9th Amendment, the ink blot, you can't find it. In fact, if you try to go to the 14th Amendment and you go through liberty and you want to go to fundamental rights, well, those are rights, according to the court, that are deeply rooted in our history and tradition. So if you go down that path, if anything, I think it breaks the tie in favor of the conjugal view. But I don't think that is right. I think the Constitution is simply silent on it. That's the point that Justice Alito ends with. He says the silence of the Constitution on this question should be enough to end the matter as far as the judiciary is concerned. So there's the argument that you can't get the equal protection conclusion without assuming a substantive position on an issue on which the Constitution is silent and the alternatives are minimally reasonable. And that's why I was citing some of the pedigree and so on. Now, here's the answer to Professor Koppelmans. Here's an answer to Professor Koppelmans' rebuttal. He will buy most of that, except for the sex discrimination stuff. And he'll say, but you don't have to say that it was intending harm to gays and lesbians in order to get an equal protection violation. You know, in homicide law, you don't have to intend the death of the innocent party to be guilty of some kind of homicide. You can, instead of having purpose or intent, you can simply have recklessness or a kind of callous indifference or depraved heart. You know, the common law is very baroque on these things, but some kind of indifference. And what does that boil down to? Professor Koppelman puts it very clearly. It boils down to seeking a trivial benefit compared to a huge collateral harm. There, you don't have to take a view on whether it's a benefit to promote the conjugal view of marriage. So, the argument goes, you can apply the equal protection conclusion. You can find a recklessness-based, depraved heart equal protection violation without taking a view on what marriage is and why it's relevant to policy. But I think that doesn't work either, and here's why. Your characterization of the benefit and your characterization of the harm will in turn depend on those two questions, what you think marriage is and why it's relevant to policy. Take a simple illustration of that. Professor Koppelman, throughout the paper that he was reading excerpts from today, by the way, he sent this paper very kindly to all of the participants well ahead of time because he's organized and on top of it. And I said that I would send him the outline of my talks at a time, and I didn't finish it in time. And yesterday at dinner, I still had just the barest skeleton. I went up to him after I said, yeah, I'm really sorry, I'm going to send this to you. He said, I know what you're going to say, which is true. So I'm not being unfair. Besides, all I said is what Alitos said. But very quickly, he suggests in a large part of the paper that the harm depends at least largely on the denial of all of these benefits to people who've made a home together. But if that was the harm, then the problem would not be DOMA. The problem would be marriage policy. The problem would be making any of these concrete benefits depend on having a certain kind of relationship as opposed to simply on sharing a household, sexual or not, romantic or not, right? I mean, this also goes to Kennedy's big conclusion. With a dramatic flair, he says, and so DOMA's purpose and effect are to establish a disadvantage, a separate status, and so a stigma. If the problem was separate status, if that was the problem, then we shouldn't have any marriage policy. The whole point of a marriage policy is to impose a separate status. Whatever your view of what that status should be, the whole point of recognition schemes in general is to say some things are different from other things. If that were the problem, it would go against all marriage policy. That's why he's assuming a certain vision of marriage against which the line that DOMA draws is unreasonable and therefore arbitrary and therefore a stigma. But anyway, so the point is that the harm can't just be the denial of benefits, or else every household that doesn't get covered on either scheme would be denied equal protection. So it must be something about denying even just the federal part of the title of marriage. But then your view of what marriage is and why we're in this business at all will determine your answer to whether it's a harm in DOMA. Right? If you think that marriage is this certain kind of relationship, intrinsically opposite sex, if you think the benefit of having a marriage policy is to uphold a vision of marriage that makes sense of these stabilizing norms and therefore in a really non-coercive way encourages people to live by them. If you think that replacing that vision of marriage with a vision of marriage as emotional union, which doesn't have to be of its nature, if it's really just an emotional bond, 3 people can have an emotional bond, you can have it with sexual openness. There's no reason to pledge permanence that outlasts the emotion if what's keeping it a marriage is the emotion. If you think that replacing that vision of marriage with the alternative vision undermines the very norms that get the state involved in the first place, then it turns out that there is a perfect one-to-one fit between the benefit of DOMA and the structure of DOMA. And the harms, which are now just have to be the dignitary harms of calling something not a marriage when it really is, aren't there, because your whole view is that this isn't a marriage but a different kind of relationship. So I think all the way down, even with Professor Koppelmans' helpful amendments to the argument, you still have to assume a substantive view about a controversial issue on which the Constitution is silent and on which reasonable people disagree, where the historical record shows that they can't just boil down that disagreement to animus or even to a particular religion.
Well, I want to say first, it's great to be back at Case. I love being here. I graduated in '97 from Case Law, and I've taught here. I taught appellate practice as an adjunct a couple of years, until this past year when I joined the faculty of the newest law school in the country as a constitutional law professor. When I began law school in 1994, I was presumptively a criminal because Bowers versus Hardwick was still in the books. I was in a lesbian relationship. And so I did feel that stigma and the weight of that stigma. And then I experienced this dramatic turn when, as a law student, I'm reading Romer versus Evans, which came out in I think it was my third year in 1996. And I was trying to understand why the court did this about face, and all of a sudden, instead of imposing this, criminalizing stigma on LGBT individuals, all of a sudden the court was issuing this pretty powerful decision affirming the right to be free of such second-class status and stigma. And that kind of became this journey that I'm still on almost 20 years later, as I put the pieces together, trying to figure out the links between the court's decisions and this evolution of this rational basis with teeth. And so here today we are with Windsor, and it feels in some ways like it's come full circle, but on the other hand, it feels like the path is just beginning for same-sex marriage. And I'm going to take a stab at answering the federalism question. It seems like we're all in agreement, so maybe I'll start all over again and talk about something completely different. But I think I have an answer as to what the court was doing in Windsor with federalism. So what I want to talk about is both what Windsor means and what it doesn't mean. And my thesis is that, in a sense, if you equate a duck with Windsor, then, the phrase, it walks like a duck, it quacks like a duck, it must be a duck. Well, in this case, Windsor may walk like a duck, it may quack like a duck, federalism, but it's actually not a duck, it's actually the swan song for federalism, and here's why. Okay, first I want to address why it's been tempting all along to think of DOMA as a case that necessitates some kind of federalist review, why people have approached DOMA in a federalist context, and why people want to interpret Windsor as a federalist decision, although I think we're all in agreement it's not at this point. But I still want to get into that because there's still a lot of prevalent viewpoints out there that it is kind of a federalist opinion, including Justice Roberts' separate opinion. I think originally it was tempting for gay rights advocates to approach DOMA as a federalist case, just out of pure caution and strategy. I think that, whenever you're pushing for the court to acknowledge a controversial right, there's a fear of losing. You've got a 5-4 court. You want to make sure you present it to the court the right way. But I think there's also a fear of winning. There's a fear of winning too big and then resulting in the same kind of backlash that you saw after Goodrich and after Bear versus Lewin, the Hawaii Supreme Court decision. That after that came out, there was this backlash. That's when he started seeing all the state DOMAs getting passed across the country. So there's a lot of caution deciding exactly how to approach the issue of same-sex marriage, how it should come to the federal courts. There was a pretty concerted effort to stay out of the federal courts at all costs. But once the ball began rolling and this challenge to DOMA was pursued, I think that there was a serious consideration that maybe to get those 5 votes, we should pursue it in the most minimalist grounds, the narrowest grounds, get agreement that even the conservative justices could accept federalism. It's too tempting of a fruit not to pluck, one scholar has written. And so, in fact, 2 of the amicus briefs filed on behalf of Edie Windsor did urge the court to treat this as a federalist issue. But there was always a danger in treating DOMA as a federalist issue, which is that if you viewed federalism as basically leaving the issue of marriages or any other constitutional issue to the states, then of course there's always the risk that the states could vote the other way. So if segregation were something that the states were really left on their own to decide whether or not to allow or prohibit segregation, despite the 14th Amendment being in place and the court saying, actually, this is a federal issue. If it were, in fact, left to the states, we'd probably still have segregation in a lot of states. Same thing is probably true of same-sex marriage. There's always going to be states that will want to prohibit same-sex marriage. So in the context of DOMA, again, Larry Tribe has explained, when looking at the Federalist argument, it serves a useful purpose for the moment, but that might ultimately become an impediment. And Professor Becker mentioned in passing the danger of majority tyranny, which Hamilton wrote about in the Federalist Papers. I mean, that's kind of what we're talking about here. Ultimately, the federal Constitution is the supreme law of the land, and there's certain things, there's certain rights that are too fundamental in the Constitution not to be voted on, not to be left to majority will. So because of these dangers of just making a pure federalist argument, the brief in chief in the end in Windsor emphasized individual rights as opposed to state power. And it really is an individual rights case in the end. But Chief Justice Roberts disagrees. Justice Roberts' dissent does actually say that, describe Windsor as the majority opinion as being undeniably based on federalism. Some scholars and news media agree, but I think if you look at the majority opinion, the text of the majority opinion itself, and you look at the context in which federalism is discussed, what federalism is doing in that opinion, it's not in the holding, it's actually in the analysis and in a very narrow and specific context. The holding, breaking apart the holding of the opinion from the analysis, and I don't have a PowerPoint here, but if you can kind of visualize the beginning and the end of the opinion, the end of Windsor, majority opinion reads as follows. The liberty protected by the Fifth Amendment's due process clause, actually, let me back up. What has been explained to this point should more than suffice to establish that the principal purpose and necessary effect of this law are to demean those persons who are in a lawful same-sex marriage. This requires the court to hold, as it does now, that DOMA is unconstitutional as a deprivation of the liberty of the person protected by the Fifth Amendment of the Constitution. And the liberty protected by the Fifth Amendment's due process clause contains within it the prohibition against denying to any person the equal protection of the laws. So it's pretty black and white, pretty straightforward. The holding is that under the Fifth Amendment, due process and equal protection are violated. Okay, there's no mention of the 10th Amendment. There's no mention of federalism. The holding itself is written in terms of Fifth Amendment, due process, equal protection. Similarly, at the beginning of the discussion, the holding is described in the following terms. DOMA seeks to injure the very class New York seeks to protect. By doing so, it violates basic due process and equal protection principles applicable to the federal government. So again, that's the holding described in terms of due process and equal protection, not in terms of federalism. So where does federalism comes in? Well, federalism, which is only 3 out of 14 pages of the majority opinion, actually, it's really not that big of a chunk of the opinion. Federalism comes in the context of the court addressing the government's justification for DOMA. And in particular, the justification that DOMA was necessary for uniformity of laws and to avoid some of these choice of law problems. And what the court explained is that there's something suspect about that justification. And going back one court, before the Supreme Court, the Second Circuit had also used federalism to basically debunk this suspect justification. The Second Circuit had explained that because DOMA is an unprecedented breach of long-standing deference to federalism that singles out same-sex marriage as the only inconsistency in state law that requires a federal rule to achieve uniformity, the rationale premised on uniformity is not an exceedingly persuasive justification for DOMA. So in other words, federalism is not the basis of the holding of the Second Circuit's opinion. It's the basis of the Second Circuit tearing down this illegitimate justification that, oh, we want uniformity of laws. Well, if that's the case, then why have you adhered to federalism all along in every other legal context? Why is it just this one law? So there's a very limited role of federalism, a very strong, powerful role of federalism, but it's not the basis of the holding. So the Supreme Court basically does the same thing. And I believe this passage has been read before today, but I kind of want to read it with a different emphasis because I think this is really the key. The Supreme Court actually says this isn't a Federalist decision. Here's what it says. It is unnecessary to decide whether this federal intrusion on state power is a violation of the Constitution because it disrupts the federal balance. The state's power in defining the marital relation is of central relevance in this case, quite apart from principles of federalism. The court's saying we're not really doing a federalism analysis here. The court goes on to say, DOMA, because of its reach and extent, departs from the history and tradition of reliance on state law to define marriage. And discriminations of an unusual character especially suggest special consideration to determine whether they are obnoxious to the constitutional provision. So again, to paraphrase, the court is saying, look, we're talking about the state-federal relation here, not because of federalism. This is not a federalism analysis. What we're saying is that DOMA deviates from a tradition of federalism respect, and that indicates, that's an indicia of discriminatory intent. Okay, so it's just a piece of the puzzle. It's not the holding itself. Okay, so discrimination of an unusual character especially suggests careful consideration. Okay, and that careful consideration is the closest the court comes to articulating what this, new heightened standard. We still don't know what the standard of scrutiny is. That's a whole other issue. But what is discrimination of an unusual character? Discrimination of an unusual character in DOMA is singling out an entire class of persons and denying them same-sex marriage rights. And what the court's really getting at here is why. Why are same-sex couples being singled out? Well, I just explained how the reason can't be uniformity, because if that were the case, then federalism wouldn't be applied to all these other contexts of marriage laws. There's no reason to single out same-sex marriage for uniformity alone. So I've also heard discussed today that, kind of to play off on some of what you were suggesting, that, that same-sex marriage is a type of classification, is a feature as such, but I would really agree with Professor Koppelman that the discrimination we're talking about here is a form of gender discrimination. Because, all right, so I have a footnote coming out in an article, and I'm going to test it out here because it's kind of fun. But it's very similar to what Professor Koppelman was arguing is, I don't see how it can be anything but gender discrimination because I'm bisexual, okay? I am. Let's say I go to the clerk of courts and I say, I'm bisexual. I want to marry this man. Is that okay? And the clerk says, well, of course, it's a man, you're getting married, what's the big deal? If I come to the same clerk of courts and say, I'm bisexual, I want to marry this woman, in Ohio, where we are, in Indiana, where I live, the answer would be, well, no, of course not. You can't marry another woman. The only thing that has changed is the gender of the person I want to marry, not sexual orientation. So this really is a case of gender discrimination. Why are we singling out gender? Why are we only denying same-sex couples the right to marry is the question. The answer can't be procreation, and I think that's something that's not addressed specifically in the Windsor decision. It wasn't addressed in the Prop 8 case, which didn't even really get to the merits of the issue. But the fact that procreation has come up over and over again today, I think highlights the fact that it will come up in the next same-sex marriage opinion. It continues to be one of the most common justifications for denying equal marriage rights. But even Justice Scalia himself, in his dissent to the Lawrence decision, he's already kind of acknowledged that that argument doesn't hold any weight. This is a quote from Justice Scalia and Lawrence. What justification could there possibly be for denying the benefits of marriage to homosexual couples? Surely not the encouragement of procreation, since the sterile and elderly are allowed to marry. I think in recent cases, the courts are more and more uniformly recognizing that those arguments just don't fly. You have plenty of heterosexual couples who use artificial insemination and other means to procreate or don't procreate at all, and they're allowed to marry. Then you have, and Justice Kennedy really recognized this in the oral arguments to Perry and in his opinion to Windsor. Children are not ignored, especially not by Justice Kennedy. I thought it was very striking in his oral arguments in Perry, Justice Kennedy raised the issue of children and kind of flipped the script. Normally, the argument has been made by opponents of same-sex marriage, oh, what about the children? Got to protect the children. It's posing a danger to children to allow same-sex marriage. And Kennedy asked that same question in oral arguments, but says, what about the children? What about the 40,000 children of same-sex couples in California who are being denied protections that marriage accords? We got real children here whose lives are being affected. So he gets that children are important. But the harm that he recognizes is denying marriage protections, because those protections flow not just to the married couple, but to their families. So children are important to Kennedy, and I think you are going to see children being mentioned in Kennedy's future opinion on marriage, in which a sweeping marriage affirmation takes place. And I think what he's going to say is that the harms to children are exactly what we're trying to prevent, among other things, when we're finally going to grant same-sex marriage rights. There is a similar passage as well in the Windsor opinion itself. Where Justice Kennedy wrote that DOMA brings financial harm to children of same-sex couples. It raises the cost of health insurance for families by taxing health benefits provided by employers to their workers' same-sex spouses. And it denies or reduces benefits allowed to families upon the loss of a spouse and parent, benefits that are an integral part of family security. So among the thousands of benefits and rights and privileges that flow from marriage are a number that really do tangibly affect children and harm them when their parents aren't recognized through marriage laws. And I think that's just the first this was just a hint, because these are not issues that were central to Windsor. They weren't, even brought up in the opinion in Perry, which didn't go in, but we will see that issue really fleshed out in great detail, I think, in the future marriage opinion. So again, I'm going through why this is not, why are same-sex couples being singled out? I do think it's undeniable that gender is at issue, that the only thing that changes between allowing an opposite-sex couple to marry and a same-sex couple not to marry is the gender of the person you want to marry. That said, there is, on the record in Windsor, this pretty clear disapproval of homosexuality. Sexual orientation does come into play, and the court's final conclusion that it's not about uniformity, it's not about these other rationales. Really what's going on here is that DOMA is based on a disapproval of homosexuality. And I think what's interesting is the court actually articulates what it views is the primary purpose behind DOMA in 3 different ways. First, the court describes what it calls the stated purpose of DOMA, and that stated purpose from the congressional record, this is an exact quote, was to promote a, quote, interest in protecting the traditional moral teachings reflected in heterosexual-only moral laws. And above that, the court cites the House record that expresses both moral disapproval of homosexuality and a moral conviction that heterosexuality better comports with traditional morality. So this disapproval of homosexuality as immoral is the stated purpose of DOMA on the congressional record. You're not going to have that a lot, but you actually have it in this case. So that is your evidence of animus that I think is going to be lacking in a lot of other cases, but it was on the record here. So then you have the demonstrated purpose. The Act's demonstrated purpose is to ensure that if any state decides to recognize same-sex marriages, those unions will be treated as second-class marriages, which raises a question under Constitution's Fifth Amendment. So then the principal purpose, so you have the stated purpose, demonstrated purpose, principal purpose. The principal purpose is to impose inequality, not for other reasons like government efficiency. So basically the court's then returning to this theme that, look, this isn't about uniformity, it's not about all the state laws being the same, it's really about imposing inequality. It's really about moral disapproval. It's really about imposing second-class status on same-sex couples. So because the court has now kind of debunked this, neutral-sounding justification and shown it for what it is, the court has basically served its purpose federalism has served its purpose in the court's analysis and doesn't really come into play again after that. Instead, the court goes on to frame its conclusion in terms of the Fifth Amendment, in terms of individual rights. So in the end, this is not a decision about state powers, it's a decision about individual rights. And the first clue that I really had that this was not going to be any usual federalism type decision is the very preface to the federalism discussion by the court, where the court actually starts off saying that sorry, I don't have this one handy because it's my favorite quote. But before the court even gets into the issue of, here we go. In order to assess the validity of DOMA, it is necessary to discuss the extent of state power and authority over marriage as a matter of history and tradition. So this is when it first starts the Federalist discussion, but the very next thing it says is, state laws defining and regulating marriage, of course, must respect the constitutional rights of persons. And Kennedy doesn't cite himself here. He cites Loving versus Virginia. So I think the fact that Kennedy starts off the Federalist discussion with a citation to Loving versus Virginia with the reminder that no matter what I'm about to say about state power versus federal power, individual rights still trump. That's basically what he's saying here. So he goes on to say, okay, state power versus federal power, really, I don't believe this justification because federalism. But in the end, individual rights trump. And I think that the framing the federalism discussion with a reminder that Loving still prevails is key. So just a refresher on what Loving does. Loving has a lot of parallels to the current issue. In Loving, the court basically said, what's at issue here is the right to choose the person that you marry. You can't deny somebody marriage rights because of the race of the person you love. Lots of parallels I could spend forever talking about with same-sex marriage, but in the end it comes down to the right to marry the person of your choice. That's the deeply rooted right. There are several other cases where the Supreme Court has recognized the right to marry the person of your choice, even in cases where traditionally a certain category of persons might not have been allowed that right. The broader principle that is deeply rooted in history and tradition is the right to marry the person of your choice. I have an article coming out in Tulane Journal of Law and Sexuality called, is it Argle Bargle, or is it a deeply rooted principle of equal liberty? In that article, since I don't have time to summarize it, I'd encourage you to read it. I think it's going to be fun, and I poke at Scalia a lot and have a great time explaining how, in fact, equal liberty really is the doctrine at play in Windsor. That's what Windsor's about. I'm sorry I didn't spend as much time talking about what it's about as I did what it's not about. But in the end, I think Windsor represents a union of equality principles and liberty principles, the merging of equal protection and due process, similar to what we've seen leading up to it in Romer and Lawrence. And now it's really come to a head, and the court is, I think, ready to affirm that same-sex marriage rights are provided by the Constitution, both under a substantive due process recognition that the right to marry the person of one's choice is deeply rooted in history, and also that liberty means nothing if it's not equally provided, and that same-sex couples should be accorded equal protections of this liberty interest under both the 5th and the 14th Amendment. So that's what I believe that Windsor really stands for. So it may quack like a Federalist duck. It's not. It's a swan song for Federalist-based marriage discrimination. And yeah, I think I'll stop there.
I have two. One is I want to follow up on something Professor Marcus said, because I think she's going to be perhaps struck down by at least the other two panelists. Not only does the evidence she cited about DOMA, that it was being done for morality issues, but in fact empiricists can show statistically significantly the difference between something passed because of principle and something passed because of animus. And they do this through public opinion polls. We know that the people vote for these laws based on whether they're going to get reelected. And so by asking the right questions on a public opinion poll, you can parse out animus from principle. So I just want to say that it's been done, it can be done, and no matter what you want to make of the congressional record, it can be shown scientifically if you believe in social science. Okay, my question really is, has to do with this idea that the Constitution is silent about marriage and that therefore you don't have to turn to originalist principles. What if I say the Constitution, forget about marriage, the Constitution is not silent about privacy? If you want to debunk that argument, you're going to have to turn to originalism to debunk that. if the case is about privacy, it does say something about privacy. What would you respond?
Sure. Well, it would obviously depend on the kind of argument you're making for privacy. I think there's all kinds of provisions and requirements and entailments in the Constitution that protect various forms of privacy. But I just don't see any way of getting from any of those, or even from a generous reading of them, to a right not just to the permission of any form of voluntary, consensual, loving adult relationship, but to its affirmation in law. Now, let me give you an example. And this speaks also to the question about what counts as animus and what counts as principle. Let's say that in New York Magazine a couple years ago, had a very sympathetic profile of a throuple, which you need a lot of new vocabulary for this debate. A throuple is a three-person couple. And in that case, it was three men who were in a relationship, who shared all the burdens and benefits of domestic life, who were in it for the long haul. They didn't want to be stigmatized. They didn't want their kids to be stigmatized. They wanted their tax breaks and their joint filings. Now let's say that someone like Jonathan Rauch comes along, a very eloquent and forceful advocate of same-sex marriage, who says there is something special about two-ness. And there's something special about privileging two-ness in our law and in our culture. There's something extra you get with the total commitment to one person as opposed to the divided commitment to two. It would be very strange to say now that he was motivated by animus, that he had something against the throuple or any member of the throuple in the profile. It would be very strange to say that this was a kind of irrational bigotry of opposing marriage equality for throuples. And it would be even more strange, I think, to say that something in the Constitution, something about unreasonable searches and seizures, or about free speech, or about freedom of any other kind that we see on whatever generous reading of the Constitution you want, required not just the permission for the throuple to live and love as they choose, but for the requirement of the state to recognize their relationship as in every way significant, similar to two-person relationships. I think the leap from the beginning, whatever beginnings in the Constitution, however read, to that third conclusion is very big indeed. Most people on both sides of the debate would think it was too big for the court to bridge, and I think it's the same size leap in the marriage debate.
And my question is for Professor Marcus, and on the reference to whether or not childbearing is a substantial interest, and doesn't that presuppose a level of scrutiny? That is to say, under rational basis scrutiny, you don't need much fit at all. Over and under inclusiveness aren't a problem. And even under at least existing doctrine for intermediate scrutiny with gender, if we look at the immigration decisions, for example, the court says all you need is a substantial relationship, and that a gender-based norm that is perhaps both over and under inclusiveness is still sufficient so long as there is a substantial relation. And so by excluding childbearing as a basis for distinguishing, doesn't that presuppose something pretty close to strict scrutiny for the classification?
Well, there's a wide bridge between rational basis and strict scrutiny these days, and I didn't really want to get into a lot of detail talking about how heightened scrutiny is evolving, but I think it is, and I think that the court is not going to apply a blindly deferential standard of rational basis, especially to cases involving same-sex couples and LGBT individuals. I think that the court has been willing to actually give some kind of real scrutiny to some of these justifications, and with Kennedy indicating that he's aware that in California alone there's 40,000 children who are at stake here. I don't think that it's going to pass the giggle test for Kennedy to say that, children are something that belong in the province of same-sex marriage, or opposite-sex marriages only.
I'm just wondering in terms of scrutiny, because he also authored the majority opinion in Guyen versus INS, which expressly validated a federal law that adopted a sex-based classification that, while perhaps largely predictive, and there's even dispute about that, was clearly both over and under inclusive in terms of the assumption that children have a natural connection with their mother that is greater than their connection with their father.
Yeah, well, I think these are the arguments that are going to play out in the next case, and they played out to a great degree at the trial level in the Perry case, and you know, a lot of the studies about, you know, the effect of whether you've got same-sex parents, opposite-sex parents, two parents, one parent, all of that played out, and I think it's going to play out again in a future case.
So this is for Professor Koppelman. I think I'm persuaded that it's a gender classification or a sex classification, but I'm not quite sure it's the same kind of sex classification. I think, as Professor Gerges points out, it's a relational sex classification. You have to look at the gender of two people, not just one, and whether they're the same. And so I'm wondering, you know, if we can automatically assume that we get to the higher level of scrutiny based on the fact that it's a gender classification. And it seems to me it depends a little bit on whether you think it's a gender blindness conception of equal protection or a anti-subordination conception of equal protection. If it's gender blindness, then I'm with you. But if it's anti-subordination, then it seems this is not the sort of classification that is traditionally used to subordinate women, right? So you'd have to make a case for a different sort of anti-subordination principle based on the historical experience of gay people, which is a case that I think perfectly plausible to make. But then you're back in the original debate, which was basically the debate about whether there should be suspect class status in the first place, right? So I'm wondering if it really avoids the debate that you're trying to avoid.
Well, the question of what, I guess it seems to me that there's a term missing here that, you know, either you're stereotyping on the basis of sex or you're subordinating gay people. One thing the court's been quite concerned about in sex discrimination jurisprudence is forcing people into roles that are traditionally deemed appropriate to their sex. So this actually is an area where liberty and equality principles do come together. The idea that, you know, you belong in this social category with these tasks, that itself is felt to be oppressive. So this is a place where I think that the traditional homosexuality taboo does come into place. Something that I learned in high school was that, I think I'm not idiosyncratic here, is that the homosexuality taboo functions to police the behavior of heterosexuals. You deviate from your appropriate gender expectations, and this label is going to be put on you. So gay people are really just a means to that end. The taboo functions equally effectively if there aren't any gay people at all. So I think that it really very much like, you know, the miscegenation taboo, which wasn't so much specifically about targeting interracial couples so much as the targeting of interracial couples as a means to policing racial categorization more generally. I think it's very much the same relationship. I've said that in other work. So I've got the floor to say something in response to Sharif on because I mean, and it's true that, I mean, Sharif's view, you know, it's an argument that was made for DOMA. You know, and Alitos' opinion actually cites Sharif multiple times. Then when I read it carelessly the first time, I thought that it was citing me. It's the first time that my name's appeared in the U.S. reports. No, he was citing Maggie in an article that has my name in the title as the person who's wrong. The question is, given that there are federal reasons for recognizing marriage as defined by state law, the federal government doesn't get to decide which marriages are going to exist. That's reserved for state law. The question is whether the federal reasons for recognizing marriage as defined by state law do or don't apply to same-sex couples. And if they do, you know, if there are reasons for wanting, say, a service member who is put in mortal danger to know that if he gets killed, his family is going to get taken care of, if those reasons do apply, what's the reason for denying the couple recognition? Is that reason even plausibly weighty enough to outweigh those reasons? And here I think it's relevant. The Defense of Marriage Act does not prevent any same-sex marriage from coming into existence. So even if you thought that you were right about conjugality of marriage, it's not clear to me that the Defense of Marriage Act advances that interest in any significant way compared with the damage that it does.
Can I just say a few things on that? The first is that it would be a huge revolution, I think, in federalism and in the federal government's powers if we said that the basis on which the federal government was justified in acting at all restricted the reasons it could consider in acting. I mean, think of interstate commerce. Think in marijuana law, can the federal government, if any of it is premised on the view, not just that it disrupts certain kinds of commerce or something, but that marijuana is a bad thing or is worth discouraging at least, it would be a huge curtailment of the federal government's powers if we said, nope, the reason it got in the business in the first place, think of healthcare. The reason it got in the business in the first place limits the kinds of reasons it can consider. The second thing, just on the question of, you're right, it doesn't make a difference to whether marriage, whether a couple has a state marriage or not. But I think you can't explain the interest in DOMA on either side, the strength of the interest on either side, without thinking that both sides see that what the federal government says marriage is will make some cultural difference. I think the strength of the interest, certainly on the pro-DOMA side, but also on the anti-DOMA side, can't be reduced just to the distribution of these particular incidents, and I tried to give some articulation of the reasons for that in my spiel. Part of it is the sense that, hey, what the federal government says about marriage also sends a signal, and that signal matters if the law's signals on marriage in general matter.
Looks like we have one last question. Go ahead. Yeah.
Okay. Thank you. So this is a speculative question, maybe more for Professor Marcus and Professor Koppelman, just because I think I know what Sharif thinks about this, but go ahead and weigh in. What I'm interested in your opinion is, okay, so DOMA is being described here as doing one thing, and it's described in Windsor as doing one thing, which is exclude same-sex couples. But of course, it actually does two things. It excludes same-sex couples and it excludes people in legal marriages that are polygamous, that are not yet two. And I would just be curious, first of all, whether you think, in Kennedy's opinion, using the reasoning he lays out, if the coupleness provision of DOMA is still good law, or if the whole definition has been struck down under that, and which kind of evades the question of whether or not Congress could pass a new law saying only couples. I don't know, but I'm just curious about what was struck down in Windsor, both parts of that definition or only the part that applies to same-sex couple, and what would be the logic of that. And since, Professor Marcus, you brought up the question of health benefits injuring children of same-sex couples, I'm just curious what you or anyone else thinks. Many aspects of federal law, beginning with Medicaid, but now accentuated because of the benefit structure of Obamacare, the subsidies in Obamacare. There are many, many children now who are being deprived of a government health benefit, specifically because their parents are married. Their incomes are considered jointly, and they are, what would be the status, in your opinion, of such government policies that deprive children of concrete, tangible benefits because of the marital status of their parents, i.e. children whose parents are married get fewer of those benefits than children whose parents are not?
Well, to answer that question, I don't know the number of children who might, in theory, but nobody's becoming married overnight because of the DOMA decision. I mean, basically, the question is who chooses, and it's a lot like the abortion debate in that sense. It's not a matter of what does the government think marriage is. It's a matter of who decides, who gets to define marriage, who gets to decide who I'm marrying. And I think what you're talking about is if a couple decides to get married, they're making a choice, and it is their choice to make, ideally under the Constitution. And if as a result of that choice, then maybe there are some government benefits that a single parent couldn't get, it's still their choice. But at least striking down DOMA gives that couple that choice instead of completely denying it to them. But I mean, as far as Obamacare, it also extends, I mean, the result of the DOMA decision is that a lot of, employers are now required to offer benefits. And I think that the number of children who can receive benefits because of employer benefits, I haven't seen a comparison, but I really do think that that number would greatly outweigh the number of couples who would be harmed because now they feel like if they get married, they're going to lose their federal benefits. I'm not sure if you're talking about welfare or WIC or what you're talking about specifically.
I said specifically was that, there are two places, just to clarify.
Yeah.
So there's awful lot of children actually dependent on Medicaid. I don't know what the numbers are, but it's huge. We tend to focus on people in our social class, so we don't see very many of them. And if their parents marry, whether it's same-sex or opposite-sex marriage, those children will lose their right to access Medicaid often because the children are being treated differently because of the marital status of the parents. So that's the issue I'm raising if under the line of the Supreme Court decision saying that the government may not treat children differently based on the marital status of their parents as a general rule, whether this would, and it's totally speculative. I mean, no one else is bringing this up, right? I'm not expecting you to have, I just would be curious about your first cut.
Quickly, because I think we want
Okay, but I would just say it's up to that couple to decide, and it should be up to that couple to decide, and that's what really the
And
issue
the
is.
government can treat
who
you
decides.
differently.
Yeah, so but certainly the fact that families get treated differently because of the income cap of Medicaid, that was the case long before Obama. That has nothing to do with Obamacare. That's just the characteristic of Medicaid. And then the subsidy, to the extent that there are subsidies, the subsidy depend on family status, and like anything else that depends on family status, it depends on who's in the family. Yeah, that's true of every subsidy for families that we've had. Obamacare isn't new in that regard. On the polygamy question, I guess one thing that Sharif said that I want to disassociate myself from is that also there in Alitos' view that there are two views of marriage, one that holds that it's essentially conjugal in the way that Sharif describes, and the other one that holds that it is essentially an emotional union. I think that marriage is a socially constructed artifact. There isn't any essentially to marriage any more than there's an essence of baseball. It's a socially constructed practice. And the question of polygamy, it's a question we all suppose that the way that marriage is understood in the United States was to radically change so that polygamy was included, and how would you deal with a mismatch between the state and federal government? It's too distant from where we are now. I don't even know how to get my mind around it. Polygamy has never been recognized by any state in American history. So it seems to me to be too far from reality for me to get my mind around.
Okay, I think we have to break because it's already 20 after, but we'll reconvene at 2:30. Thank you.
Fun as always.